Welcome back, Love Nation. This is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. We are now entering part 3 of reading the Ryan Reynolds dismissal legal documents. And without saying, there's a lot of tea in here. And we're just going to get straight into it. Make sure you guys share your comments below. Section 2, the court should dismiss all of the 6 causes of action as to Mr. Ryan Reynolds with prejudice. The FAC fails to state a claim for defamation against Mr. Reynolds. The defamation claim fails as a matter of law. It is fatally deficient because of the FAC does not identify a single allegedly defamatory statement published by Mr. Reynolds, including either of the predator statements, infra section 2A1. Moreover, to state a claim for slander, a plaintiff must plead 1. A defamatory statement of fact, 2. that it is false, 3. published to a third party, 4. of and concerning the plaintiff, 5. made with the applicable level of fault on the part of the speaker, 6. either causing special harm or constituting slander per se, and 7. not protected by privilege. A lawsuit right here, a previous lawsuit is stated in this claim. Continuing, the FAC fails to plead the claim in virtually every respect. 1. The Wayfair complaint does not sufficiently identify any defamatory statements published by Ryan Reynolds. The court should dismiss the defamation claim as to Ryan Reynolds because of the FAC does not include the allegations specific enough to afford him sufficient notice of the communications complained of to enable him to defend himself. And again, another lawsuit is cited. Continuing to read, a long line of cases in this district holds that a defamation claim is only sufficient if it is adequately identifies the purported communication and an indication of who made the communication when it was made and to whom it was communicated, citing above cases. As this court has noted, it is only by pleading the substance of the purported communication that a defendant can challenge, and upon a motion the court can determine the essential elements of a defamation claim under New York law, including whether the statement was false, whether it was capable of defamatory meaning, and whether it was of concerning the plaintiff. Another case is cited, and it continues to read, the FAC fails to sufficiently plead the substance of the predator statements, which are only ones relevant to the defamation case as to Ryan Reynolds. As to the agent statement, the FAC does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversation during which he purportedly uttered the agent's statement. See Section 8. Stating only that Mr. Reynolds used the term predator to describe Justin B. during a phone call with Justin's agent. The absence of these details make it impossible, for example, to determine whether this statement falls within the applicable one-year statute of limitations under both New York and California law for defamation. The sole allegation as to the executive statement provides only slightly more detail, namely that Ryan Reynolds and an unnamed executive at WME had a conversation during a movie premiere about Mr. Reynolds' deep disdain for Justin B., suggesting the agency was working with a predator. The FAC does not allege what precise term Ryan Reynolds used in this alleged suggestion, the sentence in which he allegedly suggested it, or any information about the context of the conversations. other than that one of them was about how much Mr. Ryan Reynolds dislikes him for having SH his wife. Such bare bones pleadings failed to satisfy Rule 8 and a warrant dismissal of a slander claim. Another court case is cited, and then, as we continue to read, dismissal for failing adequately to identify the makers of the alleged statements or either the time when or the third party to whom the allegedly defamatory statements were published. Another court case is cited. Dismissal with prejudice for nebulous claims of defamation, wholly lacking in specificity. Another court case is cited. Dismissal without leave to amend plaintiff fails to specifically allege the time, place, speaker, or listener for each allegedly defamatory statement. Now, I am going to pause right here and say this. There were several videos that leaked concerning the WME representative that were talking about Justin B. and it ends with us, which I believe they went on some sort of I don't know if it was a podcast or something, in which they were discussing this. And later, the audio was deleted, but then a part of it came out. That could be one of the instances that they're talking about. So the podcaster or wherever they were, they could actually be called upon to show all of that audio that was deleted offline. So yeah, this is going to be very interesting how this is going to play out. I'm going to read a little bit more before we wrap up this chapter. The next section, the predator statements are not defamatory because they are constitutionally protected opinion. The predator statements are an actionable opinion as a threshold matter because there is no such thing as a false idea. Courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory. Instead, opinions receive absolute protection under the New York Constitution. Court case cited. The predator statements constitute an actionable opinion because they have no precise meaning, are not capable of being objectionary, characterized as true or false, and are merely a general reflection of the speaker's viewpoint. Another court case cited. As another court in this district has explained, courts has recognized that words like scum, predators, greedy, crooks, and criminals preying on the street culture are vague, imprecise statements of hyperbole considered non-actionable opinion. Court case cited. Emphasis added. Use of colorful language such as predator, victimize, or face of evil are not actionable in and of themselves. Court case is cited right here. Calling someone crazy is a hyperbole, expression of opinion. Calling someone evil, an animal, or shameless is hyperbole. While Mr. Justin B. may not appreciate being called a predator, those hurt feelings do not give rise to legal claims because name-calling does not reflect a fact, but a non-verifiable view. And this is almost laughable again because of the Deadpool situation. And like I said before, they may have to pull up any written notes from Deadpool that might have wanted to reference Justin B. in the It Ends With Us situation, in which, you guys remember that flower shop scene in Deadpool and Wolverine. Like I said, they might have to pull that up. These statements actually did cost him his job. So if he wants to say that this was just in a joking manner because he was not happy about what he thought was going on with his own wife, the man actually lost his income behind these statements. So again, this defamation did cost Justin B a lot of money, projects, and practically shut down Wayfair Studios, as they did have 3 other movies lined up to start filming right after It Ends With Us. Not to mention part 2 of It Ends With Us that Justin B currently owns is on hold right now. And there's no word if that will even begin filming. So he did lose a lot of money after these statements were perceived to be true from the public, and he lost his agent at WME over this. So I don't know if this is going to get thrown out. I'm waiting to see what the judge says. Continuing, these First Amendment principles ought to be obvious to and even celebrated by a group of litigants who have spent most of the past few months calling Ryan Reynolds and his wife bullies and liars. And again, I'm going to pause part 3 right here, you guys. But like I said, the statements kicked off by Blake Lively and her husband essentially is how Justin B initially lost his job and his way of life, as well as his movies that were supposed to be literally in filming right now. So a First Amendment right might not be protected if Justin B's lawyers can prove loss of income and etc. and loss of reputation behind it. So we're going to see how this pans out. I'm actually going to come back with a part 4 to continue reading this document. There's a lot of tea in here. Please share your comments below. Like, share, subscribe. And until next time, be safe and enjoy your day. Bye, guys.